Hey guys, welcome to my legal classes. This is Ganesh Pujari and we were discussing chapter 17 of Indian Penal Code, which is all about offences against property. And in this series, this is my third video where I am going to deal with extortion, which has as many as 7 sections starting from section 383 to 389. I have all the details required as far as these particular 7 sections are concerned along with case law, and let's get into our first slide. Before getting into any detailed discussion on these 7 sections, I would like to give a preview of all the 7 sections within just 1 or 2 minutes. Now, what is the word meaning of extortion? I have given in different language, like in Hindi, Jaban Vasuli, or in Kannada it is Sulige. Likewise, I have given in Telugu, Tamil and Malayalam also. Try read in your local language so that you get an understanding of the term meaning of extortion. Coming to the sections, section 383 gives the definition for extortion, and there is a relationship between section 384 and 385. When an extortion is already committed by putting fear to someone else, then section 384 comes into picture, where the punishment is 3 years of imprisonment or fine or both, whereas under 385 someone is going to commit extortion. It is not yet been committed. And what are they using? They are using a fear of injury for extortion. In that case, the punishment can go up to 2 years or fine or both. Similar relationship is available with section 386 and 387 also. If someone has already committed extortion by putting someone else in fear of death or grievous hurt, in that case the punishment is 10 years of imprisonment or fine or both. Whereas if they are going to commit, that means it is not yet been completed, by putting a person in fear of death or grievous hurt, in that case punishment may go up to 7 years or fine or both. The similar relationship continues with section 388 and 389 also. Here what happens, if someone commits extortion under 388 by putting an accusation of punishment of death or life imprisonment to someone else, in that case the punishment may go up to 10 years along with fine or both. And if such accusation is under section 377, then the punishment may go up to life. The same continues in 389, but the only difference is that the extortion is not yet committed. It is going to be committed. So that is the difference. Otherwise everything including punishment remains same. Section 383 defines what is extortion. I will give that meaning and then I will give an illustration so that you can understand very clearly. It says, whoever intentionally puts any person in fear of any injury to that person or to any other, and thereby dishonestly induces the person so put in fear to deliver to any person any property or valuable security or anything signed or sealed which may be converted into a valuable security, commits extortion. Now, what are the essentials here? There must be intentionally putting a person in fear of injury, and to dishonestly induce such person so put in fear that fear to deliver to any person any property or valuable security or anything signed or sealed which may be converted into a valuable security. Now, that is too much of English. I will give a simple illustration to understand the entire scenario. The first thing you need to keep in your mind is injury doesn't mean physical injury only. It can be reputation also. That is very important. With that, I am taking you to illustration. Imagine there is one Mr. A and one Miss B, and they have illegal relationship. Now X comes to A and says if A is not paying him 1 lakh rupees, he is going to publish their illegal relationship to the public. Now that is extortion. I have two case laws here. The first case law, that is Ramesh Chandra Arora versus the state. What happened here? The accused compelled a boy and girl to take off all their clothes and then took their naked photos and extorted money by threatening them, saying that otherwise he is going to publish all the naked photos. Now this is extortion. Likewise, in the case law of Chandrakala versus Ramakishan, what happened? A headmaster threatened a lady teacher to sign 3 blank papers and else attack on her modesty, which was also held as extortion. I hope those two are very simple case laws which are giving meaning for extortion. Section 384 discusses about punishment for such extortion which is already been committed by putting someone into the fear of injury, and the punishment here can go up to 3 years or fine or both, and all those offences are cognizable offences, non-bailable offences, and any magistrate can conduct trial for the offences conducted under section 384, and these are non-compoundable offences. Section 385 is a kind of prequel or preparation for section 383. There the offence is already been committed by putting someone into the fear of injury, whereas if somebody is in preparation mode and if they are getting caught, what happens? The punishment can go up to 2 years or fine or both, and the offences here also are cognizable offences, bailable offences, any magistrate can conduct trial, and they are non-compoundable. That way the punishment is lesser than section 384 because here the extortion is not yet committed. The person is yet to commit the extortion, that is why the punishment is also less. That is all you need to remember. Till now, we have discussed all about fear of injury to the person or someone related to him. But here, the seriousness of such injury increases under section 386, which can go up to fear of death or grievous hurt. Now, if anyone commits extortion by putting someone else or his relatives into the fear of death or grievous hurt, in that case, the imprisonment can go up to 10 years or fine or both, and all of these are cognizable offences, non-bailable offences, and magistrate of first class will conduct the trial, and they are non-compoundable offences. While under 386 the extortion is already been committed, 387 discusses about preparation for committing such extortion. In that case, the imprisonment will come up to 7 years or fine or both, and here the offences are cognizable, non-bailable, and magistrate of first class can trial under this section, and they are non-compoundable offences. The only difference is under section 386 it is already been committed. Extortion is already been committed, whereas under section 387 it is yet to be committed. Otherwise everything else remains same, including the fear of death or grievous hurt. That is a very important observation which you have to make, and this is similar with all the three segments, like between 384 and 385, 386 and 387, and 388 and 389, which I am going to discuss in my next slide. Section 388 and 389 are very interesting. Till now we have learnt fear of injury, fear of death or grievous hurt. Here nothing of such sort are happening. What happens here? A person is extorting something from the another person, saying that if he or she is not going to agree for the same, then they are going to accuse them for such an offense where the punishment will go up to death or imprisonment for life. By scaring with such accusation, the person is extorting something from someone. If the offense is already been committed, then section 388 comes to picture. If he or she is going to commit, in that case section 389 comes to picture. One simple example or illustration for this can be, imagine there are two persons, one Mr. A and one Mr. X. Now Mr. X is asking 1 crore rupees from Mr. A, and he says, see Mr. A, if you are not going to pay, there is one lady died recently by name D with rape and murder, and I am going to tell the police that you have done that rape and murder. So you are going to get either punishment of death or imprisonment for life. Now what will you do? Whether you are going to pay 1 crore rupees to me or you are going to take such accusation. Now A will be scared, and if such extortion is already been committed, in that case section 388 will come to picture. Otherwise, if there is only preparation, then section 389 will come to picture. However, here the punishment under both the sections are same. What is the punishment? Punishment can go up to 10 years of imprisonment or fine or both, and if the accusation is made under the offences coming under section 377, which are unnatural offences, in that case the punishment can go up to imprisonment for life. Here, all the offences conducted under section 388 or 389 are cognizable offences, bailable offences, and can be tried by magistrate of first class, and they are non-compoundable offences. This is all you need to remember. With that, I am concluding this particular lecture. Visit my playlist Indian Penal Code for all the other Indian Penal Code related lectures, and thank you so much for subscribing my channel. Please like, share and comment my videos. All the very best for whatsoever purpose you are watching my channel, and thanks again.